If you want to learn more about the topics of today's episode, visit the podcast website at naturesecretservice.com. Thanks for listening. Okay, people, listen up. Here we go. This is Nature's Secret Service, the podcast that puts you in the room with the men and women of wildlife law enforcement. I'm Ed Newcomer, your host, and this is episode 3 of season 3, where we're doing our deep dives on wolf reintroduction and the cases related to wolves. Last week, we heard from Special Agent Tim Eicher, who told us the fascinating case about the first wolf that was poached outside Yellowstone National Park after wolf reintroduction, with the poacher being a guy named Chad McKittrick. And today I'm really happy to welcome one of my longtime collaborators and colleagues and friends from while I was a special agent. We are super lucky to have Elinor Colbourn with us. She is a former prosecutor for the U.S. Department of Justice. She was assigned for many years to the Environment and Natural Resources Division, ENRD, which handles a lot of fish and wildlife cases nationally. She is retired now, but she currently is an assistant attorney general for the state of Vermont. So now she's doing what I used to do. So we even have more in common than we used to. Just as a little bit of background before I let Elinor introduce herself and say hello, she was a huge help to me on a really annoying case I did that involved about 10 years of my work trying to chase this massive fish trafficker down. He ended up becoming a fugitive, and honestly, I could not have caught him without Elinor's help in kind of pushing DOJ to kind of move forward on the getting the warrants done and working on the extradition. So I still owe her a Coke. I'm pretty sure I owe her a Coke. Anyway, Elinor, welcome to the podcast. Thank you so much for being on. I really appreciate it.
Thanks for having me.
Yeah, it's good to see you again, and we're going to have a good discussion today.
Yep.
And if your dogs, I think you said your dogs might come in the room. That's fine. We love dogs on this podcast.
I think they're out in the grounds, out in the woods.
Okay, very good. Right
now. The cat, however, is behind me. No, he left. He was
okay. Well,
there.
We love cats here too, so the cats are welcome. Hey, refresh my memory. How long were you with the U.S. Department of Justice?
About 34 years. 34
years. That is a huge milestone for public service. You know, that's a lot. That's your professional life, really. That's a long time. Were you with ENRD the whole time?
I was. I started in the wildlife section on the civil side, doing defensive work mostly.
Okay.
And then I did a detail in the appellate section for a while, which was fascinating. But I was not prepared to spend the rest of my career mostly in the stacks of a library.
No.
I like to interact with people, and I like to argue in court, and I got to do some appellate arguments, but I was given a choice then of some different options, and I elected to ruin my career by accepting the position on the criminal side, then of the wildlife section, and then they moved 3 prosecutors and a supervisor from the wildlife section to the environmental crime section, so that all the criminal prosecutors would be together. But yeah,
I see.
A friend and I were both sort of contemplating our next steps, and we were both offered the opportunity to do the criminal work. And we had a discussion, and we both assessed it the same way, that moving to the criminal side was kind of a career planning ender, because there isn't really, it doesn't translate. You can't really take that anywhere. It doesn't really build you up very well for the private sector, except doing defense work, which we weren't really interested in. So for those reasons, he elected to stay on the civil side. And I decided I was tired of checking boxes and keeping my options open. It just sounded like so much fun. So I jumped and did not regret it. did not.
So it didn't ruin your career. You're just being sarcastic.
It just was my entire career. Yeah.
Yeah. I'd say, just so my listeners who aren't lawyers know, when we talk about appellate work, we're talking about lawyers who primarily handle appeals to, either state or federal courts of appeal, maybe the Supreme Court in the state or the U.S. Supreme Court. And it is brutal because it's really all about a lot of legal research, a lot of legal writing, and then maybe you get to do some oral arguments in front of a court. But that is not fun either, because it's not like you're doing a trial where you're presenting evidence and things things are kind of on the move. It's you speaking in front of a bunch of very well-educated judges who think they're very smart too, and they grill you. It's not fun. I hated appellate work.
It can be fun. I would say it's sort of like a Rubik's Cube. Like you turn the arguments over, and I remember one appeal that a friend of both of ours, John Webb, had handled the trial and gotten a conviction. And I started working on the appeal that she took from this conviction. And I went to him and was like, okay, so the evidence, John. And it was difficult, but I realized that the issue that she was talking about kind of wasn't the right one. Mm-hmm. And that if we looked at it a different way, we absolutely would win hands down, which we did. But it was one of those sort of aha moments where the theory had gone on down below. As an appellate attorney, you have more time.
Yeah, that's true.
To really figure it out, to really play with the arguments and twist that Rubik's Cube until everything clicks into place. And you turn it around and you see that there is no angle a judge can come at you, no question they can ask that you can't answer, that your argument isn't like rock solid. It's the only possible outcome. And that's kind of a nice feeling when you get there. But there's so much grunt work that goes into that end point.
Yeah. And okay, so this is actually the key point as to how we know that you are a much smarter lawyer than I was, Elinor, because I can't do Rubik's Cubes.
Well, neither can I. It's just a great example. It's what I imagine it would feel like. Yeah.
I'm telling you, man, it's not work I enjoyed. I didn't super enjoy being a prosecutor either, but I liked action and doing things and having to wing it sometimes. And appellate court is not like that. So I don't think you ruined your career at all by coming over to the criminal side.
So criminal prosecution. You enjoyed the being an agent part the most.
100%. Once I made the transition from being a prosecutor to an agent, where I'm the one who has to solve the crime and kind of like bring you something good, that's where I thrived. But like you, I moved to something I loved, and I stopped worrying about my career. Like I stopped worrying about that. I just started worrying about what's going to be fun and what am I going to enjoy and what am I good at, Do something you enjoy and that you're good at. Yeah, where you feel like you did anyway, right? Or you tried your best. I always tell people, even if you think we're losing the fight to protect our planet, I'd rather fight a worthy cause, even if it's a lost cause, right? So don't worry about, just be positive. We can win, but if we can't win, we still fought the good fight, right?
Yeah, and you'd get those moments. Like a lot of times it felt like playing whack-a-mole.
Yes, exactly. I've described it that exact way.
But every once in a while, changes in the law came about because of a particular case. Changes in the way something was regulated. And you could see kind of a whole industry shift. Mm-hmm. So it was rare, like maybe 2 or 3 times in my whole career. And the rest of it was largely whack-a-mole, but those little things you cling to, and you're like, it's possible to make a little difference. It's not a huge difference. You haven't changed the world, but you've changed one small piece of it. It
is. And with, when it comes to wildlife, and even, we haven't talked about this yet, but one of the things ENRD does is not just prosecute wildlife traffickers, but you deal with polluters and, people that degrade our waterways and oil spills, all that kind of stuff. But, the whack-a-mole thing, Elinor, think of it this way. This is how I thought of it when I was an agent. Yeah, a lot of times it is whack-a-mole. You let's just say you go after parrot traffickers and you take out some of the major players, and parrot trafficking goes away for a while, but it comes back. Eventually somebody else will get into that, niche. But the key is what you and I do in that interim. Once we've whacked those key moles down and they're hidden, we give parrots that breathing space to breed in the wild and kind of recover their numbers. They're not under the pressure. And that's our job is, we're never going to eliminate poaching and trafficking and polluters and all of that. We just need to whack those, violators down long enough and hard enough that we give wildlife a chance to recover and thrive. And that's, if we're doing that, we're doing our job.
It's a nice
Think of it that way, right?
I like that.
Yeah, exactly. So briefly, we last season we had 3 assistant U.S. attorneys on the same episode. You know them all. We had Mark Williams, Dennis Mitchell, and Matt O'Brien from the L.A. office. They described it a little bit, but I think sometimes people might get confused they hear about DOJ prosecutors in Washington, D.C., and then they hear about assistant United States attorneys. Can you just describe what's the difference and how do you guys work together?
It's basically sort of jurisdiction. So the assistant U.S. attorneys are based geographically. There's, right. I think, 93 U.S. attorneys' offices nationwide, and they have jurisdiction basically over every crime that happens in their geographic region. They are generalists, kind of geographic specialists, legal generalists for their work. They will split into criminal, civil, people who specialize in forfeiture, that kind of thing, but they handle it all within that geographic space. For DOJ, we are subject matter specialists. So I could go anywhere in the country to prosecute a wildlife crime. I wasn't restricted geographically the way an assistant U.S. attorney is. But I had to be prosecuting, for the environmental crime section, something that came within our portfolio, some type of environmental crime. For me, I did only fish, wildlife, and plants my entire career.
Okay.
But I could do it anywhere. And the perfect relationship between the two offices is a partnership. And most of the U.S. attorneys would welcome us and partner with us. In some cases, they just didn't. They were so stretched thin with other priorities, and this was all we did. So when an agent couldn't get the attention of a U.S. attorney because they were so busy with other things and they just didn't have the staff, they could come to us. Or if it was a particularly difficult case that a U.S. attorney might think, I don't know those statutes, that sounds really tricky to me. Either they wanted a partner or they wanted somebody else to just take it off their hands and run with it who actually knew the statutes and could therefore do it much more efficiently. That would be where we came in. Also, if it was multi-jurisdictional, so if the crime happened in more than one district, those cases would typically come to us. A lot of the long-term undercover investigations, because often when those started, you didn't know where the venue was going to be or how many different venues you would have. So we tended to get either sort of the orphaned, homeless cases or the really complicated cases.
Right.
Those were our bread and butter. Or our bread and butter.
I think so. It's an interesting relationship because it's DOJ prosecutors work closely often with the local or the district U.S. attorneys. And then, like you said, and like Mark said when he was on the show, LA's lucky it has an environmental crimes unit, but a lot of U.S. attorneys' offices do not have a dedicated unit, so they don't necessarily have the expertise or they don't have the time. So ENRD can come in and work on those cases.
I'm not sure there's more than 2 districts now that have one.
I was trying to think of that. LA, Miami still? I don't know. I'm actually not sure. The person who headed that group has retired. Yeah.
I'm not sure that LA's, have they kept theirs?
Yeah, they did keep theirs.
Great.
They always end up changing the name a little bit. So they do other things. I think right now it's environmental crimes and consumer protection or something odd like that. But yeah, they still have dedicated people to do that work, which is great. Did you ever, when you were working for ENRD, did you ever work on a wolf case?
Well, here's the thing. We've talked about that. I think so.
I think so.
Here's the answer. Yeah, I have a distinct recollection of being out west. Not at the initial court level, for the McKittrick case, but maybe on appeal.
Okay.
I know I touched it, but honest to God, I can't remember. It's been so long now. I can't remember how.
Yeah. That's okay. In the episode before yours, we talked to Special Agent Tim Eicher, and he told us about his investigation of Chad McKittrick, that first wolf that was poached. But what we really didn't get into with Tim was detail about what happened after Chad McKittrick was convicted. And he appealed his conviction on a number of causes or a number of reasons he appealed. But one of those was he claimed that the jury instruction that was given in the case, which basically told the jury, and between you and me, we're going to give a little bit of a legal background on the appeal, whatever between the two of us we can remember. But basically he appealed claiming, among other things, but one of the things was that the jury instruction given by the judge to the jury, which said that the jury did not need to conclude that he knew he was shooting a wolf when he shot an animal. That's it. Basically just that he intentionally took a shot at an animal and the animal turned out to be a wolf. That's all the jury would need to conclude. Interestingly, in the trial, there was evidence presented that he did know it was a wolf. You know, he talked to the guy next to him and said, "Hey, there's a wolf," and he shot it. And, you know, there was a lot of evidence that he did know he was shooting a wolf when he pulled the trigger. But that issue made its way up through appeals, went to the, I believe, Ninth Circuit Court of Appeals. He lost. The Ninth Circuit said that no, you don't. That's a correct jury instruction. You don't have to prove that. And then he appealed to the U.S. Supreme Court, and that's where things got a little weird. Do you want to take it from there? What happened at the Supreme Court level?
Well, so he was convicted on 3 different misdemeanor counts.
Right.
Only one of those 3 raised the issue that we're talking about, which is what kind of knowledge did he need to have about what it was that he was shooting. The Ninth Circuit followed other circuits and said, yeah, it was just good enough that you shot something and it turned out to be a wolf. When it got to the Supreme Court, the Solicitor General's office, full of very, very smart people, they looked at that jury instruction and they looked at relatively recent Supreme Court cases at that time and thought, we're not going to win on that one because the way where the Supreme Court was headed was really following a theory that a defendant in a criminal case, all of the presumptions of what the elements need to be have to come out to a culpable state of mind. So the Supreme Court was moving in the direction of the defendant has to know every fact that makes it criminal conduct.
Okay.
And so they were trying to avoid situations where conduct that would otherwise be regarded by society as innocent, unless this one little factoid was tweaked, you needed to know, as a defendant, to be a criminal, you needed to know that fact that tweaks it into the criminal realm and out of innocent conduct realm. So the Solicitor General's office looked at that jury instruction and dropped a footnote in their brief opposing the Supreme Court taking cert, saying, you don't need to look at all this because we're not going to ever do that jury instruction again, court. We don't think it matches this court's jurisprudence at this point, and so we're no longer going to be arguing that it is good enough to know that you shot an animal and the animal turned out to be a wolf. Now, it doesn't go all the way to specific intent. So what they're saying is when you pull the trigger, you need to know it's a wolf because that's a fact that makes it criminal conduct. If it was in fact a feral dog, that would be considered maybe innocent conduct or otherwise legal conduct. They're not requiring that the person pull the trigger knowing that it was a wolf and knowing that it was listed as an endangered species. They don't have to know the state of the law regarding that animal. They just have to know the biology. They have to know
the identity.
Yeah.
Yeah, that's a very good distinction, is that And according to the Solicitor General, this is what's interesting. This is where we're going to back up just a little bit to talk about this, because according to the Solicitor General, their interpretation of where kind of the Supreme Court was headed and what the law is in their mind is that a person who shoots at an animal, in order to be guilty of taking an endangered or threatened species, would have to know or believe they were shooting at a threatened or endangered species. But yes, they have to know the identity of the animal. That's it. They have
to know what the species is. They don't have to know it was a threatened species.
Exactly. Okay, right. And that is the key distinction, right? Okay, so you have to know you're shooting at a wolf, or you believe you're shooting at a wolf, but it doesn't matter whether or not you know that wolves are endangered or threatened. Yes. Okay, right. And before I get into full disclosure, me and a whole lot of other special agents and a lot of prosecutors don't agree with that. But before we get into that, let's explain what the Solicitor General's office is, because we just talked about DOJ and ENRD and U.S. Attorney's Office. Who the heck is the Solicitor General, and why are they involved in this?
They are sort of the highest attorney within the department. So they do the litigating in front of the Supreme Court. So the appellate division would handle the appellate cases. The Solicitor General handles the Supreme Court cases.
Right. And like you mentioned, these are very smart people who argue in front of the Supreme Court a lot. These are like the cream of the crop of the appellate attorneys, right?
Right. Very smart people who spend their lives in front of the Supreme Court, and they know the justices inside and out, and they know how they're likely to rule. And they really, I can't speak, well, they have a long history of maintaining their credibility in front of that court, which I think really helped them have a very strong record of wins. Because they knew where the court was headed, they knew what the court was thinking, they knew what arguments would appeal to which judge. And if they thought a case wasn't going to get anywhere, they weren't going to pursue it because they didn't want their credibility to be damaged with the court, which is understandable. They don't want to waste the court's time.
Right. Yeah. Okay. So I think this is where kind of it creates a problem from people who are opposed to what happened next. That creates a problem for us, because basically what the U.S. solicitor decided to do in this case was using their knowledge of where the Supreme Court was going, what kind of rulings had been coming out of the Supreme Court up to that time, what the personalities of the justices were. They believed that they wouldn't win on this anyway. So they just decided we're not going to use that jury instruction anymore, so don't even address the question. That, I get it, but it creates an issue, because what happened next was the U.S. Department of Justice issued a memo to prosecutors basically telling them not to use that jury instruction that was used in McKittrick, right? And that's exactly. And that's what we call the McKittrick Memo. Sometimes agents have mistakenly referred to it as the McKittrick decision. But I think it's McKittrick policy, McKittrick Memo. But where it comes down to for me, these are the problems for me. And I co-wrote a law review article about this issue if anybody wants to read it. It's a little dated now, 2011, but I think nothing's really changed since then much. But my problem is that if any lawyer in this country or any citizen who did a little bit of legal research and they looked at the highest ruling in the country, it's going to be the courts of appeal, because the Supreme Court never looked at the issue. And all of those courts agree that this jury instruction was correct under the Endangered Species Act, pursuant to congressional intent. This is what Congress intended. And so anybody who does diligent legal research will conclude that the law is very different than how it's being applied. And the way it's being applied is the result of a decision somebody who is not elected, who just made this decision based on their legal experience and locked it down with a memo, it is never going to come up for appeal again. The only way this could be changed, presumably, would be Congress has to change the Endangered Species Act to be much more specific on take, or a political decision has to be made to rescind the memo. There's no opportunity for appeal. Nobody, this is never going to come up on appeal again. And any lawyer doing research on it is going to conclude that the law is very different than how it's being applied. That's what bugs me about it.
But the provision being applied is a criminal statute.
Yes.
That is the job of DOJ, to make sure all the criminal prosecutors who would use the statute are aware of the Supreme Court case law, of the footnote in the McKittrick brief, of the U.S. position on a matter of law. Like, this is not a policy. I think that's an important distinction. That I don't disagree that there are probably some cases. I may disagree on the degree to which this has really impacted prosecutions, but and we should talk about that in a second. But I think that it is the Solicitor General's job to interpret the law as best they can. And yes, somebody could come, a different Solicitor General could come in place and say, yeah, I think the law is moved. I don't think that's the right decision, and we're going to rescind the memo or make it more nuanced or whatever. But it is their job to interpret the law. They aren't setting policy. They're not saying it's good or bad to require certain things. They're saying that this statute, as it's written, in good faith, looking at Supreme Court case law, we believe this is how the Supreme Court would rule on it. It's not how the Ninth Circuit ruled on it, but looking at the direction of the jurisprudence of the Supreme Court, that's how we believe the Supreme Court would rule on it. We are bound by Supreme Court precedent. We're not going to set ourselves up for failure. We think this is the right interpretation of the law based on everything we have to refer to in order to interpret a law. So I think it is a legislative question at this point.
Well, see, I'm not sure, because I agree with you that it is their job to evaluate cases, whether or not to argue them in front of the Supreme Court. There's lots of times when we decide, we're not going to go forward with that.
This isn't that. This isn't evaluating like the facts of a case and the law, and is it a strong enough case? Can we prove the case? This is a question of, does the law prohibit this conduct? And they're saying that the law does not prohibit that particular conduct. So there's a difference between situations which do exist where parts of government will illegally say, we don't like that part of the law right now. We're not going to prioritize it. We're not going to enforce it. And if they make a statement saying essentially categorically, we're not going to enforce a law, not that there's a difference on what the law means, but here's what the law means, we're not going to enforce it. That's illegal. That's a policy call, and that's not allowed. Congress has said what the conduct is, and you're supposed to enforce it. There are instances where you just don't have the resources, right? And you have to make priority choices. But for the most part, you can't simply categorically say we're not going to enforce the law as Congress has laid it out. That's different from saying, here's the law that Congress laid out. We don't think it prohibits this type of conduct. We think this is what it applies to, and we will enforce what we think it applies to. But we just don't think the law does what you would like it to do.
Yeah. I mean, I understand how the solicitor, got to where they were. And I don't agree with their evaluation or analysis of it, but
I didn't either at the time, but I'm a little,
you've changed. Okay.
I've come around a little bit.
We can talk about that a little bit too, but I do think when they put out the memo, they did turn it into policy. It became policy of the Department of Justice not to use that jury instruction.
The Justice Department's interpretation of law. That's different than it being policy.
Yes, but their interpretation of law is their opinion, right? So that's like officer discretion. That's just their opinion. But it is. But once you turn out a memo that says don't do it, that's policy.
They turned out a memo and said this is what the law is.
I don't know. I'll put the memo up on the website.
Well, therefore, you can't give a jury instruction that says X, because it would be wrong, because the law does not say X.
Well, yes, it is there. It is an opinion of the solicitor's office that this is what, but a lot of legal minds have disagreed with the solicitor's office on that issue. And I think one of the things that we pointed out in the law review article is that in the congressional record, when the amendments were made to the ESA on the criminal provisions, there was some discussion in Congress that they did not want it to be required that somebody have that level of mens rea. So there is some, aside from some of the other Supreme Court cases that have been cited justifying the solicitor's interpretation, those things are not there in those Supreme Court cases. Those Supreme Court cases talk specifically about how there was nothing from Congress indicating what their intent was. Well, in the ESA, there is some record of what Congress intended, and it's just kind of ignored.
Supreme Court's gone beyond that now. In more recent cases, the earlier cases were all about it can't be sort of otherwise innocent-looking conduct, and they were cases that were dealing often with strict liability types of situations, which the court has always hated.
Yeah.
But some more recent cases deal with knowledge and willfulness. And they are still coming down on saying knowledge can't be, because there's sort of a specific knowledge or almost a negligence knowledge, like, and that more recent cases have gone kind of the one step further and said it can't be kind of negligent knowledge. It has to be absolute knowledge. I knew and I did X anyway.
But what does this do to, there's a specific federal statute, criminal statute, Title 18, that I think it's a manslaughter statute. And it talks specifically about lack of due regard for what you're doing. Not that you intended to kill somebody, but that lack of due regard caused you to kill someone.
And if the ESA was written to include that kind of a negligence standard explicitly, absolutely it would be applied. But it's not written that way. It's written for knowledge.
Interesting. Even though the congressional record would show that was the intent of Congress when they passed that.
That would probably be your strongest sort of statutory construction argument.
Okay.
But it doesn't, and that's why I'm saying I think it would need to be a statutory fix at this point, because of these more recent cases where the Supreme Court is kind of really ratcheting down on it has to be culpable conduct. They have to know every fact. It can't just be that another person sort of similarly situated, a reasonable person would have concluded that fact. You have to prove that they actually knew that fact.
Right.
So the standard has sort of gotten more and more difficult. And I don't disagree that should be the standard under the ESA, right? Because you're firing a gun. There should be a requirement. The onus should be on you to know what you're killing before you kill it. And I think any reputable hunter would feel the same way. They don't pull the trigger unless they know, mistakes can happen, right? For anybody. Experts can make a bad ID. But for the most part, they're really sure of what they're pulling the trigger on. And there could be language that would acknowledge that would implement what Congress perhaps intended to do, which is sort of a stricter, almost like in the public welfare cases where the courts have accepted strict liability in certain public welfare cases because it's so important that these things not happen. And the penalty is usually so low. Well, the ESA is a misdemeanor. Right.
Class A misdemeanor, Class B for threatened.
Right. So they've accepted those situations, and this seems to be analogous to that to a certain degree. But if it could be explicit in the statute that they're talking about, there's a burden that rests with the defendant to show that there was some, they had a legitimate belief that it was something that it wasn't, or the burden is on them for knowing it. Some switch up, some recognition of sort of this negligent standard for the knowledge for the shooter that would be the ideal solution, but we all know how hard it is to get things legislated.
Yeah. Yeah, nobody wants to reopen the Endangered Species Act for amendments because they're so afraid of what the other one party or the other will try to sneak in, right, as a rider.
From what I've seen in cases since all of this happened, and there was an attempt to roll it back, but it got thrown out for lack of standing.
Yeah, the Arizona case. But before we talk about anything close to that, I want to just recognize that almost certainly anybody who's a listener of my program or a watcher who is a hunter or who's familiar with firearms, like anybody who's been trained in firearms safety, firearms use, or anybody who's been through a hunter education class, they are very familiar with the mantra of know your target and know what's beyond your target. And there are countless examples of people who have been charged with negligent homicide or manslaughter when they shot at a brown object in the woods and it turned out to be a guy in a coat and they killed a person when they thought they were shooting at an elk. And so, I know that that's what's going to be in the mind of everybody who listens to this, who's a hunter or, used to carrying firearms or using firearms. They're going to be like, wait a minute, I'm going to be held responsible if I accidentally shoot somebody. So why isn't some, asshole who shoots an endangered species?
Well, you have to remember that there's a lot of ways to take an endangered species. It's not just shooting a gun.
No,
so this knowledge level has to apply equally to all the different methods of take.
Well, yeah, but I say let that be case by case basis, right? So here's the classic example. If you're fishing using a net or even a hook and you accidentally catch a sea turtle, right? You were not even, you were not attempting to catch anything like a turtle. Okay. But if you're shooting at an animal that looks like a dog and you say it's a coyote, that's different. That's different than throwing your line into an empty ocean that you can't see, and bait or a net is not, you don't use a specific net to catch turtles versus, shrimp or fish. You don't use a specific hook to catch turtles. You know what I mean? It's just.
But in both cases.
Yeah.
If you catch it, if you shoot it, if you trap it, you're not around to see what actually gets into the trap, right?
Right.
So you could be trapping a lot of different things and you end up with a wolf.
Right.
However you take it, once you have it and you see it, like you don't know it's a sea turtle until you see it coming out of the water, that's when you have to let it go.
That's when you got to let it go. Exactly. Yeah.
And so for McKittrick, his other two counts were possessing it and transporting it after it was illegally killed.
Right.
So we're not charging him with the illegal killing. It was illegally killed. He might not be criminally liable for that, but it was illegal. And then by the time he was reduced to his possession and transport, he absolutely knew what it was.
Right.
It was now up close and personal, and there was all kinds of other evidence about taking it into a bar. And same thing with a sea turtle. You don't know what it is until you do, and then you can't possess it and you can't transport it.
Right. That's right. Yeah. And interestingly, on McKittrick, his Supreme Court case, the Supreme Court refused cert on this, right? So they didn't even hear it. They denied cert. So that means they're not even going to hear it. So he didn't win. He ended up convicted of all the things he was convicted of in district court because he lost at the Court of Appeals. Supreme Court refused to rule on it one way or the other. So it's kind of weird. His case resulted in this change in how the Department of Justice applied the law, whether you say it's a policy or just a memo implementing their legal reasoning. But it didn't help him at all. He still ended up convicted of killing a wolf. And
he would have getting counts anyway. Even if he'd gone up and won in that count, he still would have been convicted on the other two.
Exactly. And to be real clear, you explained it, but just to say it one more time, where he got into trouble on those is once he walked up and he saw, oh yeah, that's a wolf. And then now he knows if he takes it, he's going to be in illegal possession of a wolf. And if he transports it, it's going to trigger Lacey Act, all kinds of ESA and Lacey
Act. He
Act
transported it in a parade where he was celebrated as having killed a wolf, as I recall.
Yeah. Yeah, and he took the collar off, tried to hide the collar. Yeah. So, he committed other crimes.
That's why I think that there wasn't, at the end of the day, while I think this is wrong, I think the fix should be a legal fix, a statutory fix.
Legislative,
But as far as the impact on cases, I'm really interested in your view and and what you've heard from agents, because for the most part, in the cases that were brought to us during this time period, there was only one case I know of where we couldn't charge the ESA because they reduced it to possession and they transported it. And that was the Condor case. And there we had another alternative, an MBTA charge, a Migratory Bird Treaty Act charge, that is basically strict liability, maybe, but that was chargeable. But in that case, they shoot this huge bird and it gets hung up in the tree. So they couldn't reduce it to possession or transport it. They just drove off and claimed that they thought they were shooting at a turkey vulture.
The case you're referring to is an interesting one. It occurred in early, I think, 2001 in California, soon after California condors were being released to the wild again after a massive and very expensive captive breeding recovery program. And somebody shot and killed a California condor. And then Fish and Wildlife Service agents, actually from my office, but before I was hired, tracked him down. And he claimed he thought it was a turkey vulture, which they're very similar in appearance. So he was kind of getting out on the classic McKittrick, get out of jail free card. But like you said, California condors and turkey vultures are both protected by the Migratory Bird Treaty Act as well. So he committed a Migratory Bird Treaty Act violation, which is strict liability. The difference, of course, and the reason it was important to Fish and Wildlife agents was in our view, it undermined our ability to enforce the ESA. And even though both of those violations would have been misdemeanors, the ESA violation would be a Class A, which would be a maximum of, a year in jail and $100,000 fine versus an MBTA violation, which is Class B misdemeanor, much less money fine, much less potential jail time. So now you mentioned that when it first came out, you were totally opposed to the McKittrick policy/memo, but that you've changed your mind a little bit about that. Where are you now on it? You don't like it. You think it needs a legislative fix, but you understand the reasoning. Is that kind of where you are?
I think the SG made the correct call on the law.
Okay. You think the Solicitor General made the correct decision?
Yes, because the subsequent cases have really reinforced this. You have to, and I also respect why.
Yeah.
You have to know everything that makes it illegal because they want to make sure that people understand that this is truly criminal conduct in kind of a layperson's understanding of what is criminal. Because somebody has to have a culpable state of mind in order to be called a criminal. There are rare exceptions to that, again, where it's a particularly, and this would be an interesting parallel, a particularly high-risk activity with a public welfare consequence. So there are different standards for people who run fireworks factories,
right?
Things that are inherently dangerous.
Yeah. And
one can argue that shooting a gun is. The problem is that you aren't just dealing with people that shoot guns. You're dealing with people who take these animals a lot of different ways. We had a case one time where a taking was based on harassment. So this was a photographer who was getting too close to the nest. Now that's a taking, but it's not an inherently dangerous enterprise the way shooting a gun is. And if you've got a one-size-fits-all statute, you're applying knowledge to both the photographer and the hunter. You have to have the same definition fit both.
Boy, that's interesting, Elinor, because that would happen sometimes in Northern California, too, where people would kayak into the middle of a bunch of sea otters. And they would basically change the feeding or sheltering behavior of the sea otters. And under the Endangered Species Act rules, under the Code of Federal Regulations, take includes harassment, and harassment is defined as changing behavior in feeding, breeding, or sheltering.
Exactly.
Now, interestingly, I think the Trump administration is trying to change those definitions. And
yes,
and
there have been arguments over that.
Yeah, drastically.
Yeah.
Drastically trying to change harassment. But yeah, that's true. That would happen to sea kayakers a lot. They just think they were going out in the middle to look at sea otters, but they'd change the behavior of the sea otter, and that technically is take of an endangered species.
Right. And actually much easier to charge because they're going to sea otters because they're sea otters, right?
That's true.
So you're going to be able to prove that case.
That's true. But now I don't want to forget about your question. You mentioned that this turkey vulture / California condor was one of the only cases you knew of, and you were kind of curious what I knew. And we are in a future episode, we are going to talk about some of the other legal attacks on the McKittrick policy / memo that have been attempted. So we're going to get into the Arizona case in a future episode. So we're not going to talk about it too much here because it happened years and years later.
Yep.
But the main place that this seems to be having an impact is on the recovery of the Mexican gray wolves in New Mexico and Arizona. In part because they have such a similarity of appearance to coyotes, much different than the northern gray wolves. They're smaller. Their coats are almost always kind of the same, tawny brown that a coyote might have. So people who intentionally set out to kill Mexican gray wolves are very savvy to the fact that claiming it's a coyote is a way to avoid prosecution. These are very rough anecdotal. I admit these are very anecdotal numbers that I've kind of received from talking to people who know, who have worked in the area either in the past or whenever. I don't want to give anybody away. But basically, the numbers that I have written down here are interesting. Between 2017 and 2020, there were about 61 cases that it was very clear that the wolves were killed intentionally, suspicious, deaths, mortality, suspect identified, no prosecution, declined basically. Of those 61, 2 were prosecuted in 5 years. That's not good. And they've tried to take some of these cases to civil penalty through the U.S. Solicitor's Office. And so there were 2 prosecuted criminally and 3 went civil. And civil's fine. You get a fine, but you don't have a criminal record and there's no risk of jail time. So another anecdotal story I got was in over 5 years, there was 1 or 2 successful prosecutions of Mexican gray wolf killing. And human killing, outright killing of Mexican gray wolves. I'm not talking about running over them with your car because they run out in front of you. I mean, intentionally killing gray wolves in Arizona, Mexico is the number 1 cause of death among those animals. So, I can't point to specifics but I will say there are some NGOs out there trying to work through Freedom of Information Act requests to actually get the data on how many declinations there have been from the U.S. Attorney's offices in Arizona and New Mexico based on McKittrick. So I think that data is being collected, but all I have is very anecdotal stuff.
I'd be interested to know how many of those cases were then taken to the environmental crime section. Were they also turned down by them? Or was this is a really complicated, difficult proof case? It's a local, very busy office.
Yeah.
There's that. There's also, if it is people who know the lookalike, they know that loophole. If you've got circumstantial evidence that that's kind of what was going on, there's a deliberate ignorance instruction under knowledge, right? That could be used. And the last thing I would put in there, there's also the recourse potentially to where there's the similarity of appearance. You can do a lookalike listing, right?
True.
You can list another species that looks like they did originally for bald and golden eagles. Golden eagles were listed to protect bald eagles.
Right.
Now they're more endangered than the bald eagles are, but go figure. So there's that option. And then the last to me, the last piece of that puzzle, and I really don't know enough about this except to sort of, if it were me, I'd issue spot it and I'd be looking at it, is questions with DNA identification of what was actually killed. Mm-hmm. I think wolves are particularly difficult.
Yeah, that's very thorough. The DNA identification is very thorough on the Mexican gray wolves. Yeah.
Okay.
Yeah, I was actually quite surprised at how detailed they are. They know the DNA sequence of every single Mexican gray wolf that's currently in the wild. Every single one.
Wow.
Like to an individual. Yeah. And there's yeah, it's pretty impressive actually. So I think you're right about it being, that is interesting to it would be good to look at where these declinations come from, local U.S. attorneys or ENRD, because it goes directly to something an investigator told me, and that is that one of the first questions that was always asked whenever a case was taken to the local AUSA's office was, is there a McKittrick issue in this one? And so they're already, they're already thinking. So the investigators are already feeling like, oh, damn, if it is, it's going to die. It's not going to go anywhere. So you
just got to find the other charges. You got to find the workarounds.
And that was my next question. Well, that was my next question to you. As a very seasoned, experienced prosecutor, given the McKittrick Memo /policy, it's in place. It's not going anywhere as far as we can tell for now. What recommendation would you make to investigators out there about how to build the best possible case to bring to ENRD or local AUSA and that deals with McKittrick? What are you looking for?
At the post-taking conduct.
Okay.
For sure. Did they reduce it to possession? Did they take it somewhere? Did they mount it? Did they sell it? Did they take it to a taxidermist? Is there anywhere else along the chain? Or if you're there and you see the taking, don't go in and stop watch what he does next. Watch what happens to it. Or leave the carcass there and put a tracker on it and see if somebody goes back to collect it later. And
are you thinking about that in line of proving that they knew the identity when it was killed, or just that they then learned the identity and then continued to do illegal things with it?
The latter. Because it's as good a charge. It's as strong. It's an ES misdemeanor charge, Class A, just like the taking would be.
I like that. That's very good advice, Elinor.
So, I'd look at those, and then I would look at, the usual gumshoe stuff that you guys do with records and communications and stuff to see if maybe there's a conspiracy there somewhere. Maybe there's a fraud charge. Maybe there's a false labeling charge under Lacey. There may be other things with different elements that would apply to some piece of the overall conduct.
Yeah, and there are definitely other wolf cases where agents have shown that people set out to go kill wolves. Like they develop evidence during that, what you described as the gumshoe investigation, right? Mm-hmm. Where they get out and they actually find evidence that this person was intentionally going out to kill wolves. And that goes a long way to proving they knew the identity of the animal they killed, right?
Yeah. Look at what magazines they're subscribing to. What hunter training courses they took.
Yeah. Well, maybe you need a little junior special agent badge, Elinor.
There you go.
You guys have
trained me well over the years. Those are the most fun cases where I got to work closely with you guys right up through the investigation.
Oh, I'm telling you. Yeah. And you know what? It's mutual. I learned so much from you, particularly working on that Isaac Zimmerman case, trying to get him back. It's always mutual. We can bring you the realities of what it's like to be out there on the ground, and you can remind us of what the realities are like in front of a jury, which is pretty important.
One particular argument, not with a Fish and Wildlife Service agent. It was a different agency. And he's in the middle of a search warrant.
It was NOAA, wasn't it? It was NOAA. I'm sure it was.
It was not. But this agent was executing a search warrant, and there was stuff outside the scope of the warrant that was really, really important. And he's yelling at me, I'm dealing with the real world here. And I'm yelling back at him, your real world is inside that courtroom. Do not dare take that stuff. It's not covered. So I told him to take pictures of it, which he did. And when we got the warrant and he went back for it and they had culled a bunch of stuff out that he'd taken pictures of, we added a charge for obstruction.
Nice.
Yeah.
Oh, that was smart.
Again, the real world varies from your perspective, and there's more than one way to get at the end.
No, for sure. And I always tried to tell agents, when you're out in the field investigating, you have to be thinking already about how is this going to present to a jury.
Right. All the way through sentencing.
Yeah, all the way through sentencing. And sometimes you even have to be thinking ahead to appeal, right?
Yeah. Oh, yeah.
Oh, there were so many times during my investigations when I thought about, this is going to be really valuable for sentencing. It might not. This might not even be something we can admit at trial, but this is going to be part of the sentencing for sure.
Yeah.
And you really have to be to make a really clean, good case. You have to be, from the moment you arrive in the field, you have to be thinking ahead to what's going to happen at a jury, what's going to happen on appeal, and what can I use in sentencing that I might not be able to use at trial.
Yeah, I would always look at it as, until the case is completely investigated, like before charging, that the agents are the lead and I'm the advisor.
Exactly.
And then once I've got that indictment, or when I'm making those decisions for what I'm indicting, I'm the lead and they're the advisor all the way through the sentencing. But it's a team all the way through.
100%. Yeah, 100%. And I think an agent who doesn't understand that it's their case until they turn it over to the U.S. Attorney's Office, and then it's the U.S. Attorney's case. If they don't understand that, they're going to set themselves up for a lot of unnecessary conflict and failure.
Yeah, but their job is not done when it becomes. No. It's always our case. It's just a question of who's on first.
Yes, it's more of, so I look at it this way. When I'm investigating, I'm counting on support from the U.S. Attorney's Office to help me issue subpoenas, do grand juries, whatever I need to do. But once I bring it to you and you charge it, now I'm there to support you.
Exactly.
If you need me to go do another witness interview, I'll go do it because that's what you need.
Right.
Yeah, it's just a mindset of our case, but I'm the lead. Like you said, I think that's a better way to put it. I'm the lead here, you're the lead there.
Yeah, it's a team. The team lead just changes over time.
Yeah, that's a good way to put it. And then I think your other point is good in always reminding investigators that good old-fashioned detective work always pays off, right? Get out there, do the surveillance, go do interviews. Don't be afraid to go flash the badge, roll the gold, and interview people.
Well, on the next
go interview. Yeah, go interview everybody's neighbors, friends, ex-girlfriends, ex-boyfriends. Not everything has to be covert. And get out there and do old-fashioned detective work.
Read the documents.
Read the documents.
Connect the dots. Do the what was it? We used to call the agents that were particularly good at that diggers.
Diggers.
You can put together a whole case on nothing but records.
Yeah, that's true. That's true. And there are definitely some agents who are very good at the records crawl, and other agents who are very good at interviewing or sitting on a house and watching behavior. Yeah.
Takes a team.
Elinor Colbourn, thank you so much for being on the podcast. I really appreciate it. Can't tell you how much it means to me. It's great to see you. Great discussion. And I think this is going to be a very important episode for our season about wolves. Thank you so much for being on the show.
It was fun. Thank you.
All right, everybody. Thanks so much for tuning in. We'll see you next time.
Nature's Secret Service is written and produced by me, Ed Newcomer, and is co-produced by the DHTV team here at California State University, Dominguez Hills. Follow us on social media and connect with us online at naturesecretservice.com.